Well, here's a quick question for everyone tuning in. If a US Customs officer asked you to show your I-20 visa and proof of school enrollment right at the airport, would you be 100% ready to hand it over? Well, today we're going to be diving deep into exactly what you need to carry, how to avoid mistakes, and what to expect at the port of entry exactly here in the year 2025. And today's topic of discussion is going to be F-1 port of entry documents, what you must carry in 2025. So, friends, before we head on with today's discussion, and have our guest, answer all of our questions and doubts that we have, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I'm Nipasa, and welcome to Immigration Talk Show. I'm going to be a host for this session that's lined up, and our guest for discussion for today's topic is going to be none other than attorney Justin Rivera from Wasden Immigration Litigation. So, please help me welcome him back to the show. Hi, Justin. How are you doing today?
Hi, I'm all right. Thank you for having me.
Thank you so much for joining us. And must have been a long weekend. So, how did you celebrate Independence Day?
We a lot of fireworks. A lot of fireworks. Thursday, Friday, and Saturday. Staying up way too late on all of those evenings. Letting my kids stay up later probably than I should have. It was definitely a struggle this morning getting up and getting everyone back into the routine. But it was a fun weekend for us.
Absolutely lovely for us as well. So, good. And I'm looking forward for today's discussion. And folks out there, thank you so much for tuning in. You can check us out. Our handle is at Immigration Talk Show on YouTube, and also check us out on LinkedIn, Facebook, X, and on Instagram. And do not forget to hit that subscribe button if you haven't already. And also, you can contact attorney Justin Rivera from Wasden Immigration Litigation by visiting the link which you see on the screen. And yes, today's discussion F-1 port of entry documents, what you must carry in 2025. So, today's session is focused on one of the most important moments for international students, entering the US on an F-1 visa. So, what do you need to carry? What could go wrong at the airport? And how can you prepare in 2025? So, Justin, I think it's going to be great if you can tell us a little bit what can folks expect from today's discussion.
Hopefully, just get an overview of the process of application for entry into the United States. With all the changes with this administration that they've made, not only with how cases are handled at the consulate with USCIS, but also how applications are handled through CBP. I think people should be a little bit more prepared than they were even a year ago, just to understand that the process has become a little bit more complex. Now, with an F1 student, an initial entry versus someone coming back that's on OPT, there's a lot of nuance involved. So I think that hopefully we can get into that a little bit, but generally speaking, just help make sure that everyone that's traveling in probably in the next 2 months has some peace of mind because they feel prepared. They feel like they have the right documents and they're going to be able to have a smooth process.
Absolutely. And we'd really like to know, how often you assist students with port of entry and visa situations.
Well, some of our clients are people who have had issues with either DHS or CBP in the past. They may have even been people who have been who've undergone visa cancellations, things like that. So usually when you have that sort of hit on your record, it creates a presumption on subsequent entries that you're going to receive a higher level of scrutiny. So those are most of the times the individuals that we deal with. It's very rare for us to work with new F1 students, people who are just entering the United States for the first time on their visa. The reason for that is you don't really have immigration history. You don't have a tail for the CBP officer to look at. So if you're coming in for the first time, very rare that you're going to see issues with CBP typically. So most of our clients that we help are maybe someone who, had an issue in the past and now they're coming back into the U.S. after they've had to apply for a new F1 visa.
Well, that's very, very interesting. And thank you so much, Justin, for giving us a sneak peek into what we can expect in today's discussion. And I'd also
Mhm.
like to say hi to Rag. He says, "Hi, Nipa and Justin. Hope all safe amidst the Texas flooding." Well,
Thank you. Yeah, I really appreciate that. All that flooding, fortunately for us, is more in the middle of Texas. Texas is a massive state, and because Houston's close to the East Coast, we are unaffected. But that doesn't say that it isn't a horrible tragedy. Obviously, as we continue to get information about it, it definitely colored the weekend for sure. Something as horrible as that happening kind of puts a dampen on the festivities of things. But we are well. We're safe. All my family's good. Even my wife's family has people who live in Canyon Lake. They're all fine too. So thank you for that, Raj. It's appreciated.
and now let's start with the essentials. What do students need to carry? No exceptions. So, Justin, can you walk us through the complete 2025 F-1 port of entry document checklist?
I think it's pretty akin to what it's been in the past. I would say, obviously, your passport and visa. You need an I-20 that's signed by the DSO. Endorsed is the term they use. Your SEVIS fee receipt. I would recommend carrying evidence of financial support just in case that's a question that's asked by CBP. It's not 100% necessary, but I think school admission letters are helpful, especially if you're going to a known, reputable, prestigious university. I think a lot of times when they see that letter, they just say, "Oh, okay, this guy's going to school here at this place." So those are my general recommendations on what to bring. In terms of additional documentation, I think it really only becomes relevant if the individual is working. So somebody that's on OPT or STEM OPT, and those are going to be, kind of different in terms of what you need. Just making sure that you have that employment verification letter that's recent from the employer. But outside of that, those are really the docs. And the thing about it is, in today's day and age with CBP, it can be about what you carry as much as what you don't carry. And what I mean by that is this: everyone should be aware of electric search and seizures with CBP, meaning CBP has pretty much unfettered authority to go through any electronic device that you have on your person. They can ask you to open things on your computer, and if you don't comply, then that can be used as a grounds for refusal of entry. So, in addition to the documents that an individual is carrying, what they need to consider is what they are not carrying. By that, I mean laptops. Generally speaking, at this point, when it comes to dealing with CBP, I am recommending people ship their laptop ahead of them into the United States. Reason for that is this: you could be a completely squeaky clean person that doesn't have any issues whatsoever, and CBP can seize your laptop if you're traveling with it, open it up, go through it, and maybe find, I don't know, an email that was sent 3 years ago that had some sort of damning language in it regarding, I don't know, the United States' occupation of a country. Anything like that could obviously be used as a grounds for canceling your visa and having your entry refused to the U.S. So I would just avoid that problem and not travel with your computer. The other thing is obviously your cell phone. We generally tell people to ship their cell phones and carry a secondary phone that has basically just your basic necessities, your contacts, maybe your email, your personal email. If you use social media, maybe one or two social media websites. All of that stuff is appropriate, but what we try to tell people not to do is carry your basically unreviewed phone on you. Now, here's the thing: the consulate has already been instructed to scrutinize people's social media at a much higher clip now than they were doing before. So that is happening. But what's also happening, which we know, is CBP is also reserving the right to ask people questions about their social media when they enter the United States. We have had reports of people being asked questions like, what is their opinion on the current issues in Israel? We've had people asked questions about political, not necessarily Republican, Democrat, but basically political leanings on issues. And so that's all questionable stuff. But what makes it even more problematic is if they are able to, question you and then find some sort of evidence from your social media or personal accounts that has information that's counter to what you've said. Here's a hypothetical. Have you ever said, something disparaging about Israel? just an example. And then you say, no, I've never said anything disparaging about it. And they've already gone through your phone and found something on your social media where you've arguably made a disparaging comment. Now it becomes a question not only of, are we canceling this visa? It's now, are we saying that this person's committed fraud or misrepresentation because they said something to us that was false and we have proof that it was false. So to avoid all of that, I would just be very careful with your electronics. So yeah, in addition to those docs that I recommended, really scrutinize the actual electronic items you're going to carry with you as well.
Well, thank you so much, Justin, for taking that up. And well, yes, I think all devices, especially that we have become so tech savvy, we are so dependent on different technology, whether it's the cell phone, the iPad, or even a laptop. I think it's essential to know what to carry and what to not. So thank you so much for that. And also, Justin, if you can tell us, can students show a scanned or a digital I-20, or does it have to be physical?
I just bring a physical copy. There's no reason to not use a printer to put something together. You want to make the officer's job as simplistic as possible. If you have a very well, concise, put together packet of information that the officer can roll through in 5 seconds, you're in a much better spot. Let's not inconvenience someone by saying, hey, I actually have it on my phone, or don't do that. Then you're already going to be somebody that's saying, like, hey, this person, they're already not following basic decorum. Let's put them over in secondary just because they're wasting our time. So I would recommend carrying a physical copy.
Yeah, right. And then zooming in and stuff like that. So totally get it. So thank you so much, Justin, for taking that up as well. Hi, Seema. Thank you so much for joining us here on. We are going to take up your question a little later, but stay with us for now, and I hope you enjoyed the session. Also, ask your friends to join in. You can share the link and ask them to subscribe to our channel. Our handle is at Immigration Talk Show. So, Justin, is SEVIS, fee receipt still required to be printed as well?
Yeah, I would carry that document as well. Again, it's about making it as simplistic as possible for the officer that's reviewing your entry. Just have it all, like I said, in a concise packet together, and you're going to make their job a lot easier, which hopefully means that your interaction time with them is like less than 3 minutes.
Out there watching us right now, to all viewers out there, if you're packing your bags now, and you have some questions in your mind, what I can say is drop your questions in the comments. What documents that you're not very sure about, we could help you with it, and just ask your questions. Attorney Justin Rivera is here to guide us and give us some tips as well as we pack our bags. So now, though, I think we should talk about some mistakes, all about the mistakes. We see students get sent to secondary inspection or denied entry due to simple things. And there's so much to keep in mind. So, first off, Justin, what are the most common errors or red flags at the airport?
So the thing about an F-1 visa is that it is a non-immigrant intent visa. What that means is your sole goal is to enter the United States, pursue an academic field of study from an SEVP approved school, complete your studies, complete any additional actions like OPT, STEM OPT, and then depart the United States. Now, obviously, most people's pathway, if they could do it the way they want to, is you come in on F1, maybe you transition to an H1B, and once you have that dual intent, you start pursuing, possible permanent residency. All of that's well and good. However, when you're entering the United States in F1 status, particularly your initial entry, there should be no immigrant intent. So if an individual is asked about immigrant intent, then that's something that they need to be very well prepared to explain. Like, no, I don't have immigrant intent. Like I said at the consulate at this time, I don't have immigrant intent. That's one issue to look at. The other issue is when you are asked questions about where you're going to school, what kind of program are you pursuing, why did you decide to go to school in the United States, those kinds of questions, which you think are routine, normal questions, you need to be prepared to give short, concise answers. You don't want to open yourself up to additional lines of inquiry because you are rambling. So just be prepared. Be prepared to say, X, Y, Z, I'm going here, I'm living here, this is what I'm going to do. The other thing is work, questions about work. If you've come into the United States previously and you did not have work authorization, It is very normal now for them to ask you if you have worked in the United States without authorization. Obviously, the answer should be no, and no one should be working without authorization in the United States presently. Doing so is problematic, but be prepared to be asked questions in that nature too, as well as possibly, if you're taking a secondary inspection, questions about social media posts.
Thank you so much, Justin, for taking that up. And well, hello to Ricky as well. Thank you for joining us with your question. But it's now time for a short break. So, friends out there, don't go anywhere. And we'll be right back here on Immigration Talk Show. We have attorney Justin Rivera from Wasden Immigration Litigation. Today, we're speaking about F-1 port of entry documents, what you must carry in 2025. So, don't go anywhere. We'll speak more on this. It's me, Nipasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose Emmy support.
Hello and welcome back, everyone, on Immigration Talk Show. I'm your host, Nipasa, and welcome back after the short break. Today, we are speaking with attorney Justin Rivera from Wasden Immigration Litigation on this very important topic of discussion, F-1 port of entry documents, what you must carry in 2025. Speaking about the different documents or the checklist, rather, that you should keep in mind or have them ready at the port of entry, especially for F1 students out there. So thank you so much, Justin. So far, so good. And I do have more questions, so going to take them up. But I'll also like to say hello to Karthik. Hi, Karthik. Thank you so much for joining us here on YouTube. We are going to take up your question. Looks very interesting. Stay with us, all right? So next up, Justin, I wanted to also ask you about what should students avoid saying to the CBP officer?
So I would say that like we talked about earlier, the F-1 visa, it's a non-immigrant visa. You have to have non-immigrant intent. There should be no statements made about seeking permanent residency, thinking about moving to the U.S. permanently, anything like that. Should be entirely about the temporary nature of what you're doing. Now, also, your activities must conform to the visa. The F-1 visa permits you to what? Live and study in the United States. Does not give you work authorization on its own. You have to get work authorization through OPT, CPT, or STEM OPT. So in that regard, if you're asked about employment and you don't have authorization for employment, it's not a good idea to say, yeah, I'm going to go start working in the U.S. You need to explain, I may work in the future if I'm given, authorization or permission. But you don't want to just throw out a flippant statement like, yeah, I'm going to get a job, or, I plan on working once I get in, even if I haven't gone through the proper processes. Those are kind of the quick issues that I would avoid bringing up. I also would, for whatever reason, they've started to ask questions more so about the justification for the port of entry that's being chosen. And in that regard, I would just explain, I'm entering through here because my destination is Z and I can catch a connecting flight here. I wouldn't talk about the idea of forum shopping, which is basically where it's like, there are certain ports of entry where our firm, and I think lots of other firms have been saying, don't travel through there. I wouldn't use that as the basis for why you're not traveling through there. And just so we're all on the same page, I'm talking about Atlanta, Georgia, and I'm talking about Boston, Massachusetts as two areas where I would caution people traveling into the United States to go through. On a positive note, I have heard recently that JFK has actually had pretty reasonable officers that actually were willing to meet with immigration attorneys about 2 months ago and kind of go through a Q&A session of how it works and how the process of initial to secondary to supervisor review to final determination works. And so I do like JFK. So I would say if you're looking for somewhere to travel through, that would be my recommendation. But in terms of what not to say, immigrant intent, unauthorized employment, and forum shopping, your CBP port of entry.
Thank you, Justin, for taking that up as well. And I think now it's time for us to take our first comment from the viewers out there who have participated already. So let's take up our first one. This is from Seema. What if there are discrepancies in my documents, like if a name is spelled wrong in different documents? Should I worry about getting entry?
Yeah, I think that, I would be prepared to explain that up front. I think what the document is obviously important. Your name being misspelled on a passport is a monumental problem. Whereas if your name is, misspelled on fee receipt or something, just to say like, it's probably not the end of the world. However, I think that it's important to explain discrepancies in a record rather than attempt to omit them for the sake of hoping that you kind of sneak by in the process. So I would just say if you can't get that information corrected for whatever reason, just have an explanation up front as to why the information is different, but that you're still, the same individual. You're not making a misrepresentation.
Thank you so much, Justin, for taking that up for Seema. And Seema, I hope you got your answer. Now, coming to Rick's question, can premium processing increase chances of RFE for pending NIW I-140 petitions?
I mean, that's what they're all saying. There are people, particular firms who kind of specialize in EB2 NIW. It's kind of like all they do, because it is pretty nuanced in terms of, all the matter at Donzar factors and stuff. But from my conversation with other attorneys, there does seem to be kind of this blanket idea that when you apply for premium processing, they are hitting you with a generic request for evidence. And the generic request for evidence is likely being thrown out there so that they can slow down the adjudication process. So, yeah, I mean, from what I'm hearing, yes, I think that premium processing is drastically increasing the likelihood of a request for evidence.
Right. Well, Justin, what can I say? SEVIS is at the center of all of this, and students are often confused by their initial versus active status. So, if you can tell us a little bit, does CBP actually check SEVIS in real time?
100%. It is. They absolutely do. It is something that is reviewed on your initial entry and any subsequent entry. They have access to what I like to call kind of like your immigration profile, your record, and part of that for an F1 student is going to be your SEVIS information. The reason why they have that information is they can't let you in if you have an inactive SEVIS. So if you have a SEVIS that is terminated or a SEVIS that was reactivated, or not even reactivated, if you have a SEVIS that's terminated, or a SEVIS that was transferred to another school, and that transfer was done by ending your SEVIS record and creating a new record, those are also issues that you could encounter if you don't have a new visa. So yeah, the SEVIS has to be active, and they have to check that when you come in.
All right. All right. Thank you for taking that up, Justin. And so, can students enter the US if their SEVIS status is still initial?
Yeah, and that's fine, because a lot of times it's initial when you're coming in, because you're allowed to enter up to 30 days before the start date of the program, and it's your SEVIS will be initial. But again, initial is still active. So as long as it's active, you're fine.
All right. And what happens if the SEVIS record shows terminated, but the visa is still valid?
You can't come in. You're not going to be admitted. And yeah, and so that's a problem. And I think we can get into it in more detail later, but there is this idea of transferring schools and using the same visa, even if it's for another university. I think generally speaking, that's going to give you a higher level of scrutiny, obviously, but there is also like a practical effect with it with SEVIS that you have to go through. And if you don't, then you can't do that.
Okay. Okay. Thank you, Justin, for taking that up. And folks out there, drop a luggage in the chat if you've already checked in your SEVIS status, or if you're still confused, drop your questions so that we can pick them up here while Attorney Justin Rivera is still with us. He's from Wasden Immigration Litigation. So check them out as well, also on LinkedIn. So thank you so much, Justin, for so far taking up so many of our questions. And I see more questions and comments. We have Kritika also joined us, and Rag with a question, so we are going to take them up for sure. But for now, Justin, also if you can tell us a little more. Let's say a student is pulled aside. What is secondary inspection, and how should they handle it? So, what
So
documents help in that situation?
So secondary inspection, for anyone who's not aware, is basically the elevated scrutiny level for CBP. So typically when you're coming into the United States, you go through CBP, you go to an officer, hand over your documents, usually your passport, gets scanned into the system. 9 times out of 10, unless you have a previous immigration issue on your record, 9 times out of 10, you're being told, all right, you're good to go and you can come in. They have the ability to randomly select people, or, they just say, I don't like the school, whatever. They can figure out a justification to put you in secondary. Secondary inspection is where you are basically not admitted to the United States yet, and you're going to undergo an additional line of inquiry. That line of inquiry can be anywhere from 15 minutes to 6 hours. They don't have a timeline that they have to give you. And they don't have to say, we are going to admit you or not admit you until they've gone through everything. When you go into secondary, that's where the detailed electronics seizure, the search occurs. So that's where, if you have traveled with your laptop and your cell phone, that's where they're going to take those. They're going to make you unlock anything that's on there to give them access to it. And then they're going to either go through it personally, or you hook it up to a system that goes through it as well. And so that's where the risk becomes associated with traveling with that information is, are they able to do some sort of search where they procure a personal email or a work email? Let's give you a hypothetical. Maybe you have a friend that's in the United States who says, hey, after you get here, if you need some help with money, you can work at my gas station for X amount of hours, just hypothetically. And you don't even respond to that email. Well, if they see that email, they're going to then question you about it and say, do you intend to work in the United States without authorization? And so I know people think like, well, I've never had anything happen to me before. I've never had any issues. My social media is clean. All of that can be great. But if you have anything on your electronics that they can use as a baseline to deny you entry, it's going to create problems for you. And there are, specific ports of entry that are worse than others. Rog, you're right. I did talk about how I don't like the Abu Dhabi one as well. But there are ports of entry in the U.S. where if they find something, what their goal is to ensure that when you leave secondary, it is with a canceled visa. because then they can subsequently add that to their numbers to say we've refused this person entry, we've protected the United States for whatever nonsense. But that's kind of the nature. It's adverse. And so if you're put in secondary, you need to understand you cannot be denied entry unless you either give them a statement that allows them to cancel your visa, or you have a document on your person, which includes your electronics, that allows them to deny you entry, because there has to be a reason for it. They have to cancel the visa and then actually select why they've canceled the visa. So when you're in secondary, I think it's important to realize that, A, you could be there for a while, and B, you need to be very concise with your answers to questions. You need to make sure that your statements are definitive, that there's no wiggle room for them to form their own baseline to, ultimately put you into an expedited removal order, or even have you voluntarily cancel your visas. So I think you should know when you're in secondary, yes, you're in a situation that's not ideal, but you still have a level of control in that circumstance, and that you are able to explain any sort of questions that they may have. And that's the thing. As long as they don't have something to use as a justification, they cannot cancel the visa. So if you don't have any documentation on your computer or your cell phone or any communications, and they ask you questions and you say, no, I don't intend to work without authorization, or no, I don't intend to immigrate. If they don't have something, they can't just make up a reason to cancel your visa. So that's why a lot of times we like to tell people, like, it is worth it if you need the peace of mind to just do a consultation with an attorney. Talk to them about what reservations you have, what issues you have, what things could come up throughout the duration, because it is a stressful circumstance. When you're at the consulate, you're usually out, you go up to the table and you do the interview, and there's this kind of nature of like, I'm considering you for a visa. You may or may not get it. But at the end of the day, the worst case scenario is you're just told, no, you've got to go back home. You're not getting a visa. When you're in secondary, I think that a lot of people kind of get nervous. They start to kind of freak out, because what could happen there is that you could be turned around after a very long flight into the United States and told that you're not coming in. But not only are you not coming in, but you're also subsequently banned from entry for the next 5 years. So I think that is scary, and it's made more scary by the fact that the officers in secondary can utilize tactics that are pretty questionable to get people to, give up their visas. I know one big thing which we've seen a lot is the idea that, if you don't admit to something, then they are going to reserve the right to charge you with fraud, which carries with it a penalty of up to 5 years in prison. We have seen them time and time again throw that out with zero justification for how they would go about pursuing someone with a charge for fraud. It's merely a scare tactic to get you to think, oh my gosh, they can put me in jail. And then, you're not thinking straight anymore, and you're just agreeing to whatever they say because you want to get out of the situation. I've had clients that has happened to, where they've literally admitted to things that they have not done because they just want to get out of being in CBP's clutches. And they can and will question you with multiple officers. They can and will leave and come back after long periods of time because they want to wear you down. But I have had individuals that I have worked with who have been questioned by CBP for up to 7 hours and then admitted to the United States, because at the end of the day, there was no justification for them to cancel the person's visa. So if that is the case, and as long as you stick to the facts of your circumstance and situation, you should be fine. That being said, I get that it is a scary situation. And like I said, it's probably in your best interest for peace of mind to at least have an initial consultation. If you're not even going to talk to an attorney, there are actually former consular officers who offer services now, like prep interview services. And I would recommend, if you don't want to talk to an attorney and maybe it's a little cheaper, to at least talk to somebody like that, because they're a little bit more dialed in the process, and they should be able to provide you with assistance.
Okay, thank you so much for the detailed explanation, Justin. And I also wanted to ask if a student, can the students carry a lawyer's contact or DSO letter in case of trouble as well?
So, yeah, here's the thing. You can carry that document, but whether or not it's going to be honored by CBP is completely up to their discretion. You do not have a right to counsel if you have not been admitted to the United States. And so, until you are actually admitted by CBP, they do not have to honor the legitimacy of a G28. Now, is it good to have one for peace of mind to not only show the officers that you are represented by counsel, but potentially to give you an avenue to, request a conversation with counsel? Yeah, I think it's definitely good to do because it puts them on notice, for one thing, that, this person actually has an attorney. And secondly, it shows that you've probably been vetted. You've been trained to come through CBP. They know you're not going to be an easy mark, someone that they can kind of manipulate into having your visa denied or refused. So I would say that, you can bring them, and I would recommend bringing them, especially the G28s. But at the end of the day, that does not guarantee you a right to speak to your attorney.
Right. Thank you so much, Justin, for taking that up as well. And it's time now for another short break. So, folks out there, I hope you're enjoying this discussion. And if you have more questions, keep commenting because we are going to take them up after this break. So, thank you, Rag. I see them already. Stay with us because we are going to pick up your comments right after this short break. We are speaking with Attorney Justin Rivera today from Wasden Immigration Litigation on this topic, which is very important for especially the F1 students out there. F1 port of entry documents, what you must carry in 2025. So don't go anywhere. Let's go for a short break and we'll be right back with me, Nipasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Nipasa, and today it's been superb speaking with Attorney Justin Rivera from Wasden Immigration Litigation, and we have been discussing on F1 port of entry documents, what you must carry in 2025. And I hope that you have been enjoying this discussion and must have been very helpful because it's been so super informative so far, with the checklist to keep in mind and different situations even or how to deal with them. So thank you so much, Justin, for being with us today and helping us with answers to all of these questions we have for you. So yeah. So Justin, I do have more questions, but I think we should pick up some questions from our audience as well right now. So let's pick up this next one. This is from Karthik. Karthik is asking, what should Indian students expect during CBP inspection at the airport? And are there any recent changes in F1 visa enforcement that Indian students should be aware of?
Yeah, so I think generally speaking, if you're coming in on an F1 initially, you're probably not looking at much scrutiny above maybe social media vetting. I will say people that are returning that have work authorization, OPT, STEM OPT, I'm a little more worried about those individuals because I do think those programs are being more heavily scrutinized. So I think that that's something to be aware of. I've also not seen this directly, but I have heard that the so-called day one CPT schools, these universities that offer second master's programs or PhD programs with immediate work authorization, I have heard that those individuals are seemingly getting a little bit more pushback when they go through CBP. So I would be cautious if you're traveling and you are doing day one CPT. Honestly, I would probably say stay in the United States at this point, but those individuals, I think, definitely need to be prepared to be asked additional questions. There's a big push by Stephen Miller, who you know renowned, not awesome person. There's a push now with him to basically try to remove work authorization for student visitors. Like, that's not something they can do just immediately. They can't just create a policy that says, okay, now you're not allowed to have work authorization or have OPT. That's something that's going to take time. But what they can do is attack people at ports of entry that are utilizing that work authorization as a way of kind of backdoor going after the program. So that would be something that I would be just a little more cautious of if you're in that circumstance. That being said, in terms of changes with the F-1 program, there is currently a desire to change the expiration date from DS, which is what it currently is for F1 students, to definitive end dates. And we're not sure if that end date is going to be a program specific end date or if it's going to go semester by semester. But that is something that they're working on. It looks like they've actually already submitted a proposal. So that's a change that they're going to want to do this year. And looking at it from, what's the worst case scenario and what they would probably prefer, which is because it would be a way for them to make the immigration system even more difficult, is by forcing people to apply for extensions semester by semester. And so what they basically would say is, yeah, you can come in the United States and maybe your F-1 visa is valid, for X amount of years, the same way it's always been. But while you're here, you have to actually, stay in compliance by applying for an extension every semester. Hopefully that doesn't happen, because honestly, it's just going to be a waste of money and time for everyone. But because that's what it would result in, I feel like it's something that they would be interested in doing.
All right. Thank you, Justin, for taking that up for Karthik. And Karthik, thank you for your question. Very interesting. And Rag also has a question, so we'll quickly take that up. Two questions. Recall your thumbs up for Seattle, Port of Entry, and down for Abu Dhabi. What is your advice for work visa holders, H1, L1?
So yeah, I still like Seattle. I'm a pretty big fan of most of the West Coast ports of entry. They seem to have better trained officers, or at least less predatory officers than some of the ones on the East Coast. My advice for work visa holders, for H1s and L1 holders, if you're traveling into the U.S., just make sure your documents are current, and make sure you have a recent employment verification letter. It definitely seems like they're asking more questions now about people who are contract workers who work for third-party locations. There seems to be a very big push to force individuals to affirm that whatever project or assignment they've been given is active at the time they are entering the United States. So that's going to be important. So make sure that your information is up to date in terms of your employment verification letter. And also, as I said, with the F1 and anybody traveling in the U.S., your electronics should be considered and scrutinized prior to coming in. I wouldn't recommend anyone travel in with a laptop anymore if you can avoid it, since there's the option of shipping it ahead of you. And then, like I said about phones, I recommend carrying a secondary phone and shipping your primary phone in. If you think that's too extreme, I would just make sure that you're able to look through all of your information and ensure that there's nothing in there that could be construed as problematic. Moving to a project before the project has been filed, project has ended, and you're coming in to start on a new project where there's no amendment yet. Something like, we'll file an amendment once you're back in the U.S. Things like that are buzzwords for them, where they're going to key into those if they look into your not social media, they look into your electronic devices. So that's why I would be cautious about it regardless, but especially for an H-1B or L-1, because they are scrutinizing those, especially the H's heavily for contract workers. Another really important thing to bring up while I can remember it is we have received confirmation that through whatever way, CBP is able to access deleted text messages and emails. So just because you have deleted something off of your phone doesn't mean necessarily that they cannot find a way to get access to it. So that's something to be aware of as well.
What can I say? Well, it's sometimes doesn't it creep you off, this scrutiny, I would say.
Yeah, I mean, I think if you use it for what it's supposed to be used for, which is, thwarting terrorism, then it's good to be able to do that. To extrapolate the justification being national security into let's go find everybody that's ever, talked about paying for an H-1B fee or premium processing, anything, just anything that you can find to open the door to deny someone entry. No, I don't agree with. It's ridiculous. I mean, the social media aspect alone of it is now just gone to this very heavy extreme where you're not only having social media reviewed at the consulate, but basically saying CBP gets a second crack at the apple just because they can. So it's very surprising. I mean, even 2 years ago, I think that you would be able to tell someone when they go to the consulate to get a visa, you would say, go get a visa and don't talk to me again until you're back in the United States, if you're an employer. And you would feel safe doing that. Now, the risk now exists that when that employee leaves the U.S., not only do you worry about, well, at the consulate, do they get hit with a 221G and just get sat in, where they rot while their case gets looked into, or they do get the visa and then they go to CBP and something completely unrelated to their employment comes up and they end up getting hit with expedited removal. Then they're out of the U.S. for at least 5 years unless they can get a waiver, which I'm going to be really honest with you guys. You're not getting a lot of waivers in the Trump administration 2.0. It's not going to happen. So, I think it's a difficult situation, but as long as you can prep as much as possible, which is why I tell everyone now, talk to an attorney before you go interview, before you come into the U.S., like, it gives you at least that leg up versus someone who's just going in there blind. Because I definitely think that I know that our conversation is primarily about CBP, but the consulates themselves, I mean, they are getting really smart at weeding through people and getting people to basically admit to things without even realizing they're admitting to it and getting their visas denied, but because of that basis. So, I know I just went on kind of a bit of a tangent there, but yeah, H-1B and L-1s, update your EVLs and consider the travel with your electronics.
Thank you, Justin. And Rag says, thank you already. Helps much. Thanks, Justin. Thank you, Rag, once again. And let's take up Kritika's comment as well. She has a question asking, what happens if a student arrives at the US airport with an expired travel signature on their I-20?
I think that could conceivably be grounds for denial of entry. And I think probably, like I said, even a year ago or 2 years ago, you're probably not seeing the same level of scrutiny as you're seeing today. But when the CBP officer is working backwards from denying entry as the goal, then I think that you should make sure everything is correct and dotted and fresh at the time of entry. So I would not recommend people attempt to enter with an expired travel signature on an I-20.
Okay. Well, thank you, Justin, for taking that up. And well, folks, keep commenting. We will take up more questions, but it's time now for another short break. So don't go anywhere. You're watching Immigration Talk Show with me, Nipasa. And today we're speaking with attorney Justin Rivera on F-1 port of entry documents, what you must carry in 2025. Don't go anywhere. We'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm Nipasa, your host for today's session, and it's been superb speaking with attorney Justin Rivera from Wasden Immigration Litigation. And we have been discussing on this topic, which you can see on the screen, F-1 port of entry documents, what you must carry in 2025. superbly, very helpful so far. And we have been taking up comments from our viewers, lovely viewers out there. Thank you so much for being so participative. And do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram as well. Stay connected with us and keep commenting. We will take up your questions. Hi, Jatin. Thank you so much for joining us. We are going to take up your questions. But, Justin, I just wanted to throw some edge cases. What if your plans change after the visa is issued? So, can students use a valid F-1 visa from a different school?
So, yeah, sorry, I kept showing that I was muting and unmuting. Yeah, this is where the whole SEVIS transfer comes into effect. If someone has an F-1 visa approved to school A, and then they transfer to school B, if they do a proper SEVIS transfer, which is going to involve cooperation between the old school DSO and the new school DSO, then it is possible. So if the SEVIS transfer occurs, your SEVIS number remains the same, then you can use an F-1 visa from a different school. Now, what is legally permissible and what is recommended may be two different things. Because while legally permissible, the fact that the school name is different can open you up to scrutiny at CBP. So even if you go through the process and do it all correctly, you could still end up in a circumstance where CBP is going to put you in secondary inspection because of that change. Now, that being said, I think that the change is more problematic for individuals who are enrolling in, the quote unquote day one CPT schools. I think those are the cases, the circumstances that are going to be looked at with a higher level of scrutiny. So yes, you can do it, but you have to do it the right way. If your old SEVIS terminates during the process, then your F-1 visa is done. That visa is done and you have to go get a new visa. So if you can go through the transfer process properly, then yes, it can work. Do expect to see additional scrutiny at CBP.
Okay, and Justin, also, what about entering early, maybe much before the 30-day window?
You can't do it, not with your F-1. You're only allowed to enter up to 30 days before the program start date. Now, if you have a different visa, like a B2, and you enter on that visa, then it's permissible. But for the F-1, you're not going to see entry allotted before that day, before that 30-day before program start date threshold.
Okay, and what about, the transfer pending I-20? How does a transfer pending I-20 affect entry?
So it shouldn't affect entry because it shows that you're going through the process, the SEVIS transfer process correctly. And since it's in process, it should be okay. That being said, same thing as I said previously in relation to the changing schools and using the same F-1 visa. Anything out of the ordinary creates a presumption of scrutiny. It allows CBP a way in to begin questioning you. Did you ever intend to go to the first school? Why did you enroll in the first school? Why are you transferring to the new school? When you enter, which school are you going to be attending? What program are you going to be studying? All of those things are now questions that would not be asked if your I-20 did not say transfer pending.
Thank you, Justin, for taking that up. And, now it's actually time to take up more questions from our viewers out there. So I think, Control, if you can also display some of our questions. And meanwhile, let's address Jatin's question asking, Sir, will the same be applied to B2 tourist visa? Do you think it will be easier for me to pass the CBP since I have been to US previously, 7 years ago? I have been to the US with J visa at that time.
As long as you're re-entering on a B2 visa and you have well-defined plans for your entry, I think you should be fine. The problem is, the problem becomes when you were here previously, did you ever demonstrate immigrant intent? Was anything ever filed for you that would show immigrant intent? If that's the case, then you could see scrutiny. Otherwise, when you're coming in on a B2 visa, what they're really looking at is that you're going to conform to the conditions of the visa, meaning you're not coming here to work. You're not coming here to transfer to another visa after you've been admitted. You have a well-defined entry and exit date, and you have strong ties to your home country or wherever you'll be going after you've been in the United States. So as long as you meet all of those factors, you're not going to see, much heavier additional scrutiny. The people that are getting in trouble and having their B2s revoked are um, people who are coming into the United States but are basically not giving definitive travel plans, not saying that they've purchased a return ticket. Or the other one that I saw that was a big point on social media not too long ago was the individuals who came in who admitted that they were going to continue working for their foreign affiliate companies while they were in the United States. And so the B2 obviously is a visa that does not permit employment. And even though these individuals were talking about employment with their foreign companies, not a U.S.-based company, because the work was being done while they were on U.S. soil, CBP saw fit to cancel their visas, claiming that they would perform unauthorized work. So those are all things that are going to need to be taken into consideration on a B2.
Thank you so much, Justin, for taking that up. And Jatin, thank you for participating. So, Control, if you can display the questions from our viewers from YouTube and Facebook, would be great. So, this one is F1 visa interview waiver status change. Refused, it means to attend interview. Changed, refused. It means to attend interview. I think that's the question.
Uh, okay. It really just depends. It depends on if it changes to refused. Usually, if it's updated to refused, you're going to get some level of correspondence from the consulate, either a 221G or a request to come in and attend a physical interview. I think, yes, typically if it's an interview waiver that you had and it changes to refused, it does mean that they are updating it to where you have to come in and attend an in-person physical interview.
All right. Thank you, Justin, for taking that up. This now the next one. Hello, I recently completed my undergrad and will be joining for my grad degree starting in fall 2025 at the same university. I have applied for change of degree in my I-20. I am planning to travel to India for about a month with my family. Looking at the news, is it safe to travel? I have a valid passport.
Uh, I mean, look, no travel is 100% without risk at this point. That's just how it is now. If you have a clean immigration record, you don't have any issues in the past, then I don't think that you should be extremely concerned about travel. That being said, I would say that it is safe for you to travel, but you need to travel with the understanding that entry to the United States is never guaranteed, and it's now more heavily scrutinized than it has been at any time in the past probably 8 to 10 years. So there is some risk, but if you have nothing in your immigration history, you've never had a previous visa denial, visa refusal, denial of a change of status, extension of status, anything like that in your immigration record, and you have not, uh, worked with any of these problematic OPT employers or H-1B employers. If none of that is in your record, then I think you're safe to travel. But if any of that stuff is possible or something that may have impacted you, I think traveling is significantly risky at this point.
Thank you, Justin, for taking that up as well and for that tip. So, yes, and Control, if we can take more questions. Hi, I am on F1 visa. I have stamped visa. I have valid passport, valid I-20. DSO signs my I-20. I am planning to go to India for 1 month. Is it safe?
And it's the same thing as the last question, pretty much. It would be the same thing. Now, like, look, if you've got a valid visa, you're not going to have to apply for a new visa. That's great. That it deals with part of the process for you. You don't have to deal with the consulate. You're still going to have to deal with CBP when you enter. As long as you have all your documents, if you have no previous immigration record history, then I think you should be okay. That being said, CBP is going to do what CBP does. Depending on where you enter, it's probably going to show how much scrutiny the officer is going to give you. So there is still some risk involved in traveling, but if you have no immigration hiccups, then you're generally safe to travel. If you do have any previous immigration hiccups, I would strongly consider thinking about not traveling during the present administration.
All right. Thank you so much, Justin, for taking that up as well. And Okay, following up, I have made a mistake in my DS 160. Can I change it? My interview date has not been booked yet.
I'm not sure if you can edit a DS 160 that's already been submitted. I mean, it might be possible, but I know you can always do a new DS 160. So I don't know why, if you couldn't, not, I mean, I know it's a pain in the butt, honestly, because doing the DS 160 sucks. But if you want to just do a new DS 160 to be on the safe side and then book your interview, you might be able to do it that way.
Okay, okay. Well, we see more viewers join us. Slayer Gaming, Kinwa. I think, Justin, if you have a couple more minutes, we'd like to take them also.
Okay.
Okay, but on the screen, okay. So let's take this one from Slayer asking, is the port of entry for F1 students getting tight for this fall?
I mean, I don't know, to be honest, and I know a lot of people aren't able to enter yet because it's not 30 days or less before the program start date. So we're kind of going to have to wait and see. That being said, I would expect them to do something. If I'm playing, like, what's the worst case scenario, I expect them to do some level of training going into the fall for F1 students to vet them, because when you guys are coming in, that's an opportunity they have to do expedited removals and count those towards deportation numbers. And so it wouldn't shock me if they were trained to kind of target people that are entering on F1 initially, just to see if they can catch a couple people and put them in removal. So, that's speculative. I generally don't know yet. So we're going to have to wait and see. I will say, I think it behooves anybody to at least have a conversation with an attorney or some sort of prep agency before coming into the United States, just for peace of mind.
Thank you so much, Justin, for taking that up. And now let's take up Kinwa. There is a rumor if you enter CBP late night or 2 a.m., the officer is less tight. Sorry. The officer is less tight at this time and they are tired already. Do you think there is the truth into it? What do you think?
I don't know. I have no idea. Generally speaking, I tell people that have difficult immigration matters to travel on weekdays and travel during normal business hours, because, like any business, the officers who are going to be the most well trained and have the most seniority, they're going to get the best schedules. So 9 times out of 10, that means those officers are the ones that are getting the kind of 9 to 5s. The people outside the 9 to 5s are usually going to be the younger, newer, more inexperienced officers. And I actually find those officers to be more problematic because they lack experience, but also sometimes seem to lack training in a way where if there is even one thing out of order, they're putting somebody in secondary because they just don't know what to do. And so it's basically saying, I'm going to let my supervisor figure it out because I don't know the answer. I actually try to tell people not to travel in on times like that. So that would be my opinion on it. And that being said, like we've kind of talked about, if you have no immigration hiccups, nothing that has come up on your past, no issues, you can travel in whatever time you want. If you don't have to do explaining for something or give a justification for why you have a previous denial or something like that, you're probably okay to travel whenever. So that's kind of my general opinion on it.
Thank you. Thank you so much for taking that up, Justin. And we have Farza. Sir, if I only bring two small luggage with the help with the CBP, will be more okay rather than carry big luggage. I'm afraid the suspicious if I carry big luggage. Please advise hand pick waving. Hand pink waving.
I think maybe he was trying to make an emoji, like a little hand come up. Um, yeah. So look, here's the thing. You can bring carry-ons, obviously, when you fly, and you can also have checked bags. CBP has the right, if they put you in secondary, to go make you go get your checked bags and bring them in to the room for inspection. So it doesn't really matter if you're traveling with small bags or big bags. It really doesn't make a difference. At the end of the day, the thing that I think is much more important is what electronics are you traveling with and how much access are they going to get through those electronics.
Thank you for highlighting that, Justin. And I think we should definitely wrap up this session with a quick fire checklist. So if you can just tell us quickly your top three golden rules for F1 port of entry in 2025.
I mean, it's just, have your docs, passport, visa, I-20 signed by DSO that's unexpired, fee receipt, evidence of financial support, school admission letter. Have all your docs, put them together in a real easy, concise manner. So that way you can just hand everything over as it's requested. Don't have to be the guy or gal digging in your bag for stuff. You're going to annoy the officer. So just don't do it. Um, So that's one. Two, non-immigrant intent. You're coming into the U.S. to study. You're coming into the U.S. to get a degree. That's why you're coming here. You're not coming to the U.S. because you're going to live here in 10 years permanently. So the goal is non-immigrant intent. Three, unauthorized employment. No unauthorized employment. If you're asked about work authorization and you don't have it, say you'll think about it when you get it. Don't talk about working in the United States when you do not have authorization to work in the United States.
Thank you, Justin. Very helpful, I'll say. And this next one is, what's the best way for students to prepare in the 48 hours before flying?
I would just talk to an attorney, do a prep call. 30 minutes. 30 minutes of your time gives you peace of mind. Even if you're not doing it with me, do it with another attorney that can help you kind of be prepared to come through. If it's your very first time coming into the United States, it could give you some level of peace of mind. If it's your 45th time coming into the United States and you've been coming in and out of the United States for 4 or 5 years, I would stress even more that you talk to an attorney, because we're going to have the ability to point things out to you that you may not realize are issues in your immigration record and help you head those off in the event that you're questioned by CBP.
Absolutely, yes. And friends out there, if you want to contact attorney Justin Rivera, check out this link which you can see on the screen. And yes, thank you so much, Justin. So we do have Kinwa just asking, requesting you to please take this last question. So we'll just take this and wrap it up. Justin, do you think the CBP officer know if I previously rejected, then get approved the visa? I got approved later on, but rejected once.
Yes, they do know that. That's going to be in your immigration history. And so that's the kind of thing where, what was the reason for the rejection? I guess to kind of point it out was it looks like the visa was rejected. So, visa refusals can vary widely. You could have something like a 214B, which is just saying you're not going to comply with the visa that's being issued with the conditions of the visa. Those are general, usually not something that's going to create inquiry. If you're denied for some other reason or basis, then perhaps that is going to lead to a higher level of scrutiny. So that would be a circumstance where I would recommend you talk to an attorney about the basis of your previous denial and see if there's any need to kind of prep or strategize around being asked about it at the port of entry.
There you go. Thank you so much, Justin, for your time today. Had a great time. Very, very informative. And I hope everyone out there, all our viewers, are making the most of this session we had today with attorney Justin Rivera from Wasden Immigration Litigation. And if you are traveling very soon, especially if you are an F1 student and you need an attorney to consult with, why not check out or call attorney Justin Rivera? You can check out the link and get his contact details. So thank you once again, Justin. It was lovely having you. Always an honor and a pleasure.
Thank you very much for having me. You guys have a good rest of your day, all right?
You too. Bye-bye. Well, Kinwa says, thank you, sir. We'll see your page on the consultation. Appreciate it. Thank you so much, actually, Kinwa, for actively participating today. It was lovely having you and your questions. And to all folks and viewers out there watching us, also, for being very participative, for your questions, and you made this session an even a better one. So also, we will drop a free checklist link in the description and comment section. So yes, friends, all of y'all, thank you so much for joining us, especially attorney Justin Rivera for joining us today here. It was lovely having you. And follow us, all you folks out there, for more F1 visa prep sessions. And if you missed any part, the replay will be available right after this. So go check it out. And thank you once again. If you also want to contact me or have any questions that you want to drop or email me, you can email me at neepatstaffingly.com. I also have a number where you can WhatsApp me or call me. My number is 408-335-6444. And well, we do have more questions. Hello to K99 Gaming. Any update on August visa bulletin? Well, we will update you. We'll be the first to update you very soon. It's almost, the normally it's out within the 10th or the 15th for the next month. So it's 7th today. Should be out in another couple of days. So we will update you for that. Thank you, K99. And Rag says, thanks, Nipa. Thank you so much, Rag. Always lovely having you. So thank you, each one of you, once again. Have a wonderful day ahead and stay tuned on Immigration Talk Show because we have a lot of information that you do not want to miss out on. So check out our space and bye for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.